in our city and in our country. We are glad that all of you are here for this special occasion. For my brief comments, I'll paraphrase Robert Kennedy, who spoke so eloquently about justice. Few of us will have the greatness to bend history, as the Friendship Nine have done. But each of us can work to change a small portion of events within our own actions, and by example, touch the lives of others, so that in the total of all of those acts, it will be confirmed and recorded that justice is for all people, and that injustice must not be tolerated in any place at any time. The history that is bent straight here today serves as an example through the actions and lives of the Friendship Nine, and is what courage looks like when good people step forward to lead. To all of us as witnesses here today, and to future generations, this is a special moment. The court proceedings will begin shortly. Thank you again for being here.
All rise.
Spell down. Open down.
The Court of General Session of York County is now in session. The Honorable Judge John C. Hayes III is presiding.
Thank you. You may be seated. As our governor is used to saying, and it couldn't be any more appropriate to say today than it's a beautiful day in South Carolina. We're glad to have all of you here. I am John Hayes, Circuit Court Judge, along with Dan Hall. We have resident judges in our circuit, the 16th Circuit. I'd like to thank Mayor Eccles, Judge Modler, and the City Council for them allowing us to utilize these chambers for this historic proceeding. The purpose of this proceeding is for the court to hear a motion on behalf of 9 Friendship College students. One of the individuals, Mr. Gaither, who is named as usually with the Friendship Nine, actually was not a student but an activist on behalf of civil rights. But the proceeding is to hear a motion on behalf of these Friendship College students and some members, 4 members of the Student Nonviolent Coordinating Committee. Of course, the individuals from the Friendship are known as the Friendship Nine. At this time, I'm going to recognize Judge Modler.
May it please the court?
Yes.
Your Honor, as a York County Circuit Court judge with ultimate jurisdiction over all cases in the Rock Hill Municipal Court, I present to you the official record from the Clerk of Court, Diane Anderson, in the cases before us.
All right. Thank you.
From the original docket, dated February 1st, 1961, I publish the following. Defendants, when your name is called, please stand or raise your hand as appropriate. Docket number 407, prisoner Charles Ed Taylor. Offense, trespassing. Disposition, guilty. Sentence, $100 or 30 days. Conditions, sent to chain gang. Docket number 408, prisoner James Frank Wells. Offense, trespassing. Disposition, guilty. Sentence, $100 or 30 days. Conditions, sent to chain gang. Docket number 409, Prisoner Clarence Henry Graham. Offense, trespassing, disposition, guilty. Sentence, $100 or 30 days. Conditions, sent to chain gang. Docket number 410, prisoner Robert Lewis McCullough. Offense, trespassing, disposition, guilty. Sentence, $100 or 30 days. Conditions, sent to chain gang. Docket number 411, prisoner Thomas Walter Gaither. Offense, trespassing, disposition, guilty. Sentence, $100 or 30 days. Sent to chain gang. Docket number 412, prisoner Willie Edward McLeod. Offense, trespassing, disposition, guilty. $100 or 30 days. Sent to the chain gang. Docket number 413, prisoner Mac Cartier Workman. Offense, trespassing, disposition, guilty. $100 or 30 days. Sent to chain gang. Docket number 414, prisoner Willie Thomas Massey. Offense, trespassing, disposition, guilty. $100 or 30 days. Sent to chain gang. Docket number 415, prisoner John Alexander Gaines. Offense, trespassing, disposition, guilty. Sentence, $100 or 30 days. Conditions, sent to chain gang. Docket number 416, prisoner David Williams, Jr. Offense, trespassing, disposition, guilty. Sentence, $100 or 30 days. Sent to chain gang. And these are from the original docket dated February 1st, 1961 of the Rock Hill Municipal Court, signed by the Honorable Billy D. Hayes, uncle to John. Judge Hayes, I turned the page, and from the original docket dated February 7th, 1961, I published the following. Docket number 469, prisoner Diane Judith Nash, C.F. Offense, trespassing, disposition, guilty. Sentence, $100 or 30 days. Conditions, county jail. Docket number 470, prisoner Ruby Doris Smith, C.F. Offense, trespassing, disposition, guilty. Sentence, $100 or 30 days. Conditions, county jail. Docket number 471, prisoner Joseph Charles Jones, C.M. Offense, trespassing,
We're back now at
disposition,
8:41
guilty.
with the undoing
Sentence,
of a
$100
historic
or 30
injustice in
days.
South Carolina
Sent to chain
today. A
gang.
judge is expected.
Docket number 472, prisoner Charles Melvin Sherrod. Offense, trespassing, disposition, guilty. Sentence, $100 or 30 days. Conditions, sent to chain gang. Signed, the Honorable Billy D. Hayes. Thank you.
Thank you. In just a moment, I'm going to recognize Chief Justice Finney. Chief Justice Finney, who was my boss for a while, and I still admire and still do what he tells me to. And he, along with the Honorable Matthew J. Perry, represented the Friendship 9, or actually the 10, on the day they represented them, at the time of their conviction for trespass in the Rock Hill Municipal Court. I'm going to recognize him in just a moment for the purpose of making a motion. However, I would be remiss if I did not note that both Justice Finney and Judge Perry have their own poignant experiences with the unfair humiliation and effects of segregation. Justice Finney, as a young licensed attorney, unable to join the all-white South Carolina bar, waited tables at the old Ocean Forest Hotel for the members of the South Carolina bar at their convention. Judge Perry, as a member of our armed forces during World War II, standing in his uniform in the pouring rain at a train station diner in a southern railroad station, standing at the window marked colored, looking in and seeing white Italian prisoners of war inside the warm diner, dry and enjoying laughs with the waitress. Justice Finney and Justice Perry, like the 9 and the other 4 individuals, have walked this road. Now, I call on Justice Finney for the purpose of making a motion. Justice Finney.
May it please the court. Today I am honored and proud to move this honorable court to vacate the convictions of my clients, now known as the Rock Hill Nine. These courageous and determined South Carolinians have shown by their conduct and the faith the relief that they seek should be granted. We appreciate the cooperation shown by the 16th Circuit Solicitor's Office in assisting with this hearing, with which much could be said about the insults these citizens endured in the 1960s. Let the decision of the court today show the resolve of South Carolina to work together, to learn together, and to progress together, and to ensure the promises set forth in our Constitution, that all men are equal under the law. On behalf of the named defendants, I move for the convictions to be entered in 1961 be vacated, and the court to issue an order affirming for good cause shown that justice and equity demand the motion be granted. Thank you very much.
Thank you, Justice Finney.
Excellent job. Okay. I want you to sit down, too.
Now call on Solicitor Brackett, who is joined by Deputy Solicitor Weta Dest, to respond.
Good morning, Your Honor, and may it please the court. I have a challenge following the Honorable Chief Justice Finney. I should just say I agree and sit down, but custom
that's what I always
dictates,
do.
Yeah, it's probably the prudent thing to do, but custom dictates that I lay out reasons for why I agree with the Chief Justice. The facts in this case are very straightforward, Your Honor. On January 31st, 1961, 10 students from Friendship College marched down to Main Street to take a seat at the McCrory's Five and Dine lunch counter. They did this knowing that the McCrory's lunch counter was a segregated whites-only lunch counter. They did this for the sole purpose of laying themselves before the conscience of the community and putting their very freedom at stake to make the point that the segregated lunch counters in Rock Hill and across the South were wrong, and that the policies and laws that supported these segregated counters and other segregated facilities, public facilities in the South, were wrong, and that something needed to change. They sat down. They did not create a disturbance. They did nothing untowards while in the diner that would have warranted their removal from the diner. But upon sitting down, almost immediately, they were seized by law enforcement officers, taken out of the diner, placed under arrest for trespassing. The record is abundantly clear. There is only one reason these men were arrested. There is only one reason that they were charged and convicted for trespassing, and that is because they were black. That could not happen today. It was wrong then, it's wrong today. And these convictions, if they are allowed to stand, would be an offense to justice, and they must be vacated, and the charges must be dismissed. Now, I could stop there and say that's enough, but I think I need to say more. First, before I get to that, though, we have recognized the members of the Friendship Nine that are here, and we've also recognized 2 members from the Student Nonviolent Coordinating Committee that were arrested approximately a week later. But there's one person that's in this courtroom whose record is not going to be cleared today because he has no record. He was not charged, although he gladly would have joined these men in jail, I know, if he could have, but he couldn't be charged because he was white. And he exhibited, in the face of overwhelming public pressure and popular opinion, an extraordinary courage and an extraordinary amount of determination in supporting these men. And I am, of course, referring to the catalyst of the community, and we are honored to have him with us today, Brother David Boone. As I said, getting these convictions vacated and having these charges dismissed is important, but that is not all that is owed to these men. My wife tells me frequently that sometimes, Kevin, you just need to say, "I'm sorry." She tells me that a lot. And I think that if this day ended without me, as a representative of the state, extending an apology to these men, we wouldn't be doing justice in this case. Because these convictions and charges were had in the name of the state. And today, as solicitor for York County, I represent the state. So allow me to take this opportunity to extend to each of you my heartfelt apologies for what happened to you in 1961. It was wrong. But one more thing, if I may, Your Honor, because apologizing isn't enough either. Our community here and our country is a better place because of what y'all did. You all sacrificed your own freedom to make our country better by making a statement about how segregation was unjust and wrong. It's a better place for me. It's a better place for my daughter. And for that, I owe you my thanks. 2 years after you finished serving your sentence, sitting in a jail cell in Birmingham, Alabama, Martin Luther King Jr., sitting in his own jail cell, wrote a letter in response to some criticism that he received because of the perception that he was in Birmingham causing problems and tension and that there was unrest there, and essentially asserting that they were outside agitators. And in this letter, he indicated in response, he said, one day the South will recognize that the men who are engaging in these activities are heroes. One day they will be recognized as the heroes that they are. I have absolutely no doubt that as his pen formed those words, he was thinking of these men right here. And so I would just like to say that on behalf of the state, I am glad that that day has come. You are my heroes. Thank you.
I am going to grant the motion, of course, with a formal order that I will read into the record. Copies of the order will be distributed to each of, a signed copy to each of the defendants, who collectively I will refer to as the Friendship Nine. They have, pursuant to Rule 29B of the South Carolina Rules of Criminal Procedure, moved for a new trial and acquittal based on after-discovered evidence for their 1961 convictions for trespass. This court is vested with jurisdiction to hear, consider, decide, and rule on the defendant's motion pursuant to Article 5, Section 11 of the Constitution of our state, the state of South Carolina, the 1895 as amended, and Rules 29 and 37 of the South Carolina Rules of Criminal Procedure. Additionally, and to the incident and inherent power of a circuit court by virtue of its constitutional authority, and because exercise of its power in this instance is necessary to accomplish the purpose of this proceeding. While no testimony or exhibits have been presented in this hearing, I have established the underlying facts set forth in this order through the exercise of judicial notice pursuant to Rule 201 of the South Carolina Rules of Evidence. The sources of the factual information are noted in footnote 1 of the order. There are a few footnotes in the order. I will not read them. On the morning of January 9, 1961, a group of 18 young African-American civil rights demonstrators, 13 men and 5 women, most of whom were students at Friendship College, a college located in the city limits of Rock Hill, South Carolina, converged on McCrory's 5, 10, and 25-cent variety store in downtown Rock Hill. Authorities had been notified ahead of the time that there would be protest, and by 8:30 that morning they were on duty in case of trouble. Initially, the protesters marched up and down the street carrying protest signs. Then male demonstrators went inside the store and 10 of the young men sat down at the counter and refused to leave. At around 11:30 a.m., the 10 young men sitting at McCrory's lunch counter were arrested and taken to the city jail just some 100 yards behind the McCrory's store. The following day, the protesters were tried in the Rock Hill City Recorder's Court for trespassing. The protesters were represented by Chief Justice Ernest A. Finney, who now again represents the Friendship Nine, and who was our state's first African-American Supreme Court Chief Justice, and the late Matthew J. Perry, who became a United States District Court judge and for whom the federal courthouse in Columbia is named. All 10 of the protesters were found guilty and sentenced to a $100 fine or 30 days of hard labor at the York County chain gang. The National Association for the Advancement of Colored People offered to pay the protesters' fine. Only one accepted this offer so he could benefit from an athletic scholarship. The remaining 9 refused to pay the fine and did serve their chain gang sentences at hard but useless labor. The Friendship Nine's strategy of opting for jail rather than paying their fine became known as jail, no bail. This strategy was effective not only to break the cycle of arrest, bail, and release, an expensive cycle, but also to bring national attention to the invidious nature of segregated public places and private commercial concerns open to the public in general. The Friendship Nine were joined by other defendants whose names are in the caption and have been named today, members of the Student Nonviolent Coordinating Committee. They came to Rock Hill in unity and solidarity with the Friendship Nine, and also, upon arrest, opted to remain in jail rather than pay their fine. The sit-in movement, which I have seen referred to sometimes as jail-in, had its birth at a Woolworth store in Greensboro, North Carolina in February of 1960. The jail no bail strategy was initiated here in Rock Hill by the Friendship Nine. This became an important strategy of the sit-in movement. The arrest of the Friendship Nine for their sit-in at McCrory's was not unique to them or to the city of Rock Hill, as evidenced by the arrest of over 3,000 protesters or sit-in participants out of over 70,000 who participated by August of 1961. And I note a typo in my order, and we'll correct it. I have 7,000 in the order, and it should be 70,000. The actions of the Friendship Nine became nationally known and nationally adopted by those seeking deserved equality in a society still segregated almost 100 years after Abraham Lincoln's Emancipation Proclamation and of the proposal and passage of the 14th Amendment to the Constitution of the United States. Those are the factual basis of this order. In April of 1963, Martin Luther King Jr. wrote one of the most compelling treatises in the form of a letter to 8 white religious leaders who had declared the use of nonviolent protests to be, quote, unwise and untimely. On the state of justice for he wrote the letter on the state of justice for African Americans and for people of all races and colors. This, of course, is the letter from the Birmingham jail, 1961. Dr. King wrote that he was in Birmingham and in jail, quote, because injustice is here. Dr. King opined that nonviolent protests were necessary because of the existing power structure with those who were treated unjustly, no choice. Like the Friendship Nine, Dr. King presented his very body as a means of laying out his case for unjust treatment before the, quote, conscience of the local and national community, end quote. Dr. King stated that nonviolent actions such as that of the Friendship Nine, quote, demonstrated the issues, quote, such that, quote, it can no longer be ignored, end quote. Dr. King observed that those for whom he spoke had, quote, not made a single gain in civil rights without determined legal and nonviolent pressure, end quote. This quote is followed by Dr. King's observation that segregation was an unjust law as it was, quote, not rooted in eternal and natural law, end quote. Further, Dr. King defines an unjust law as, quote, a code that a majority inflicts on a minority that is not binding on itself. Dr. King recognized Rosa Parks and James Meredith's stands for justice. Dr. King also, while not directly mentioning the Friendship Nine, recognizes, quote, the college students sitting in at lunch counters and willingly go to jail for conscience sake, end quote. History shows that the city of Rock Hill and their recorder's court were not unique in what now seems to be selective enforcement of laws, as in this case, the law against trespassing. What happened in Rock Hill was mimicked in Greensboro, North Carolina, Marshall, Texas, Atlanta, Georgia, and elsewhere. What happened in Rock Hill was unfortunately and inexcusably a societal, not a local phenomenon. It was at that point in the evolution of the United States the accepted practice of the majority. There are other observations not in the annals of legal precedent which dictate the court taking the action here and below. While not of legal precedential value, these observations rank high on the barometer of justice and are worth consideration and are applicable to the facts of this case. Daniel Webster, on Mr. Justice's Story, published in 1845, stated, quote, "Justice, sir, is the greatest interest of man on earth," end quote. Benjamin Disraeli, Lord of Beaconsfield, stated in a speech in 1851, quote, "Justice is truth in action," end quote. To paraphrase Daniel Webster, man's greatest interest is justice, simple fairness, and equality for all. This is a motion for a new trial based on after-discovered evidence. To obtain a new trial based on after-discovered evidence, the moving party here, the Friendship Nine, and the other four, must show that the evidence, number one, would probably change the result if a new trial were held. Two, has been discovered since trial. Three, could not have been discovered before trial. And four, is material to the issue of guilt or innocence. And five, is not merely cumulative or impeachment. The analysis of the defendant's motion here does not compartmentalize well with the traditional notions of a new trial. Defendant's motion focused not on the underlying evidence which formed the basis of the conviction, but on the gravity and efficacy of that evidence. Defendant sat in at a 5, 10, 25-cent variety store lunch counter in seats reserved for white patrons. Being in the 5, 10, and 25-cent variety store was not the basis of their arrest and conviction. The Friendship Nine were not even prosecuted for the occupancy of the stools, per se. They were prosecuted solely based on their race. While such arrests were the norm at that juncture of history, the discussion here above recognizes then, as now, no one may be prosecuted based on their race alone. Such prosecution is, on its face, unjust under any definition. While it seems an exercise in absurdity, the court finds that the evidence used to convict the Friendship Nine was patently flawed, unjust, and anathema to society's evolved recognition of the illegality of laws which perpetuate segregation. If tried today for the offense for which they were convicted, the Friendship Nine would be acquitted. While society tolerated the enactment of and enforcement of segregation laws in 1961, such now are recognized as repugnant to society's moral code and to the core principles of justice, fairness, and equality. The flawed and unconstitutional evidence upon which the Friendship Nine's conviction was based is material to the issue of their convictions. The new evidence, which could be referred to as actually the recognition of the absence of evidence at defendant's trial, is not cumulative, nor is it impeaching. The new evidence knocks the underpinning of their convictions completely away, and therefore the convictions are not bottomed on any evidence. In conclusion, now is the time envisioned by Dr. King when he recognized and acknowledged that those who, like the Friendship Nine, sat down at lunch counters were in reality standing up for the best in America's dream and our most sacred values. We cannot rewrite history, but we can write history. Now, as to the Friendship Nine, is the time and opportunity to do so. Now is the time to recognize that justice is not temporal, but is the same yesterday, today, and tomorrow. I therefore order that the defendant's motion for a new trial based on after-discovered evidence is granted. The defendant's convictions for trespassing in January of 1961 are vacated, null, void, and set aside. The record reflects no competent evidence supporting the charge of trespassing as to these defendants, so the charge is based on the arrest of the defendants at McCrory's 5, 10, and 25-cent variety store in downtown Rock Hill for trespassing are vacated and dismissed with prejudice. As I said earlier, each of the defendants will receive a copy of this order. A copy will be filed in the docket book for this court, and this is Mr. Hamilton, our clerk of court, and in our general sessions in the office of the clerk of court in the general sessions division. Today is January 28th, and I am now signing the order, and that is done. Now, Mr. Brackett has one other issue he wishes to call to the court's attention.
Yes, sir. May it please the court if I may indulge the court for just one moment.
I think they're all in agreement with that.
Your Honor, as Your Honor is aware, in any case where charges are dismissed or a not guilty verdict is found by a jury, state law mandates that all the records related to those offenses be expunged and obliterated. In this particular case, given the historical value and nature of this particular incident, I believe that the gentleman and counsel for the defense are all in agreement that we will waive those provisions so that this incident and what these men did, instead of being obliterated, hopefully will be remembered for many generations to come, and these records should stand in that regard.
I think that is eminently appropriate, and I do understand, just as a little aside before we adjourn, that students quite frequently come, I'm told by the clerk here, to actually look at the docket book and see where these convictions are enrolled. A copy of my order will now be interfaced at that page in the book, and that will, while not acting as an expungement, and I can understand why an expungement is not wanted and of course will not be, no expungement will be entered, this will remain part of our history as corrected. So we will adjourn, but before everybody else, I'm going to adjourn and exit, but I understand there are some individuals who are going to make some remarks, so if everyone else other than me will remain seated while we hear these other remarks. I think a podium will be placed out here, so give us a minute to do that, and I'm glad all of you were here today and got to watch this wonderful moment on this beautiful day in South Carolina. Thank you. I thought it went well.
I think it did. It was moving to see Justice Finney speak like that. I mean,
I'm glad he was able to do it.
I'm just saying, maybe if we can get a photo op with all of you all in this dress.
it was great.